Hello viewers, in the continuation of our previous lectures on cyber security, today we will discuss the topic intellectual property rights. Intellectual property refers to creation of the mind, inventions, literary and artistic works and symbols, names and images used in the commerce. Intellectual property is divided in two categories. The one is industrial property, includes patent for inventions, trademarks, industrial designs and geographical indications. Copyright cover literary work such as novels, poems and plays, film, music, artistic work, etc. and drawing, painting, photographs and many more things. And architectural designs rights related to the copyright includes those of performing artistic in their performances, producers of the phonographs in their recordings and broadcasters in their radio and television programs. Now, we will discuss what are the intellectual property rights. Intellectual property rights are like any other property right. They allow creators or owners of patents, trademarks or copyrighted works to benefit from their own work or investment in a creation. These rights are outlined in Article 27 of Universal Declaration of Human Rights, which provides for the right to benefit from the protection of moral and material interests resulting from authorship of scientific, literary or artistic productions. The importance of intellectual property was first recognized in the Paris Convention for the Protection of Industrial Property 1883 and the Berne Convention for the Protection of Literary and Artistic Works 1886. Both treaties are administered by the World Intellectual Property Organization, which is called WIPO as well. Now, we will discuss why promote and protect intellectual property. There are several compelling reasons. First, the progress and well-being of humanity rest on its capacity to create and invent new works in the area of technology and culture. Second, the legal protection of new creation encourages the commitment of additional resources for further innovation. Third, the promotion and protection of intellectual property spurs economic growth, create new jobs and industries and enhance the quality and enjoyment of life. An efficient and equitable intellectual property system can help all countries to realize intellectual property's potential as a catalyst for economic development and social and cultural well-being. The intellectual property system helps strike a balance between the interest of innovators and the public interest, providing an environment in which creativity and invention can flourish for the benefit of all. Now, we will discuss how does the average person will benefit from this. Intellectual property rights reward creativity and human endeavor, which fuel the progress of humankind. Some example, the multi-billion-dollar film, recording, publishing and software industries, which bring pleasure to the million of worldwide, would not exist without copyright protection. Without the rewards provided by the patent system, researchers and inventors would have little incentive to continue proceeding better and more efficient products for the consumers. Consumers would have no means to confidentially buy products or services without reliable international trademark protection and enforcement mechanism to discourage counterfeiting and piracy. Now, we will discuss what is the World Intellectual Property Organization. Established in 1970, the World Intellectual Property Organization, which is called WIPO as well, is an international organization dedicated to helping ensure that the rights of the creators and the owners of intellectual properties are protected worldwide. and that inventors and authors are therefore recognized and rewarded for their ingenuity. This International Protection Act as a spur to the human creativity, pushing back the limits of the science and technology and enriching the world by literature and arts. By providing a stable environment for marketing products protected by intellectual property, it also oils the wheels of international trade. WIPO works closely with its member states and other constituents to ensure the intellectual property system remains a supple and adaptable tool for prosperity and well-being, crafted to help realize the full potential of created work for present and future generation. Now we will discuss how does WIPO promote the protection of intellectual property. As a part of the United Nations system of specialized agencies, WIPO serves as a forum for its members states to establish and harmonize rules and practices for the protection of intellectual property rights. WIPO also serves as global registration system for trademarks, industrial designs and appellation of origin, and a global filing system for patents. These systems are under regular view of WIPO's member states and other stakeholders to determine how they can be improved to better serve the needs of the user and potential users. Many industrialized nations have intellectual property protection systems that are centuries old. Among newer or developing countries, however, many are in the process of building up their patent, trademarks and copyright legal frameworks and intellectual property system. With the increasing globalization of trade and rapid changes in technological innovations, WIPO plays a key role in helping these systems to evolve through treaty negotiation, legal and technical assistance and training in various forms, including in the area of enforcement. WIPO works with its member states to make available information on intellectual property and outreach tools for the range of the audience, from the grassroots level through to the business sector and policy makers, to ensure its benefits are well recognized and properly understood and accessible to all. Now we will discuss what is patent. A patent is an exclusive right granted for an invention, a product or process that provides a new way of doing something or that offers a new technical solution to a problem. A patent provides patent owner with the protection for their inventions. Protection is granted for a limited period, generally 20 years. Why are the patents necessary? This is very important questions. Patents provide incentive to the individual by recognizing their creativity and offering the possibility of material reward for their marketable invention. These incentives encourage innovation, which in turn enhances the quality of human life. Then we will discuss what kind of protection do patents offer. Patent protection means an invention cannot be commercially made, used, distributed or sold without the patent owner's consent. Patents rights are usually enforced in the courts that in the most system hold the authority to stop patent infringement. Conversely, a court can also declare a patent invalid upon a successful challenge by a third party. Now we will discuss what rights do patent owners have. A patent owner has a right to decide who may or may not use the patented invention for the period during which it is protected. Patent owners may give what role do patents play in everyday life. Patented inventions have pervaded every aspects of human life, from electric lighting and sewing machines, patents held by Howe and Singers, to magnetic resonance imaging, MRI, patents held by the and any iPhone's patent held by any Apple and anything else. In return for the patent protection, all the patent owners are obliged to publicly disclose information on their invention in order to enrich the total body of technical knowledge in the world. This ever increasing body of public knowledge promotes further creativity and innovation. Patents therefore provide not only protection for their owners, but also valuable information and inspiration for future generation of researchers and inventors. Then we will discuss how is a patent granted. The first step in securing a patent is to file a patent application. The application generally contains the title of the invention as well as an indication of its technical field. It must include the background and description of the invention in clear language and enough details that an individual with an average understanding of the field could use or reproduce the invention. Such descriptions are usually accompanied by a visual material drawing, plans, diagrams that describes the invention in a greater detail. The application also contains various other forms like that is information to help determine the extent of protection to be granted by the patent. Now we will discuss what kind of inventions can be protected. An invention must in general fulfill the following conditions to be protected by the patent. First is it must be of practical use. It must show an element of novelty, meaning something new, characteristic that is not part of the body of existing knowledge in its particular technical field. The body of existing knowledge is called prior art. The invention must show an inventive step that could not be deduced by a person with the average knowledge of the technical field. Its subject matter must be acceptable as patentable under the law. In many countries, scientific theories, mathematical methods, plants or animal varieties, discoveries of natural substances, commercial methods or methods of medical treatments are not generally patentable. Then who grant patents? Patents are granted by national patent offices or by regional offices that carry out examination work for a group of countries. For example, the European Patent Office and African Intellectual Property Organization. Under such regional systems, an applicant requests protection for invention in one or more countries, and each country decide whether to offer patent protection within its borders. Then the WIPO Administrated Patent Cooperation Treaty provides for the filing of a single international patent application that has the same effect as the national application filed in the designated countries. An applicant seeking protection may file one application and request protection in as many signatory states as needed. Then we will discuss what is a trademark. A trademark is a distinctive sign that identifies certain goods or services produced or provided by an individual or a company. Its origin dates back to the ancient time when craftsmen reproduced their signatures or marks on their artistic works or products of functional or practical nature. Over the years, these marks have evolved into today's system of trademark registration and protection. The system helps consumer to identify and purchase a product or service based on whether its specific characteristics and quality as indicated by its unique trademark meet their needs or not. Then what do trademarks do? Trademarks protection ensure that the owner of the marks have the exclusive right to use them to identify goods or services or to authorize others to use them in return for the payment. The period of protection varies, but a trademark can be renewed indefinitely upon payment of the corresponding fees. Trademark protection is legally enforced by the courts that in the most systems have the authority to stop trademark infringement. Then we will discuss what kind of trademarks can be registered. Trademarks may be one or a combination of the words, letters and numerals. They may consist of drawings, symbols or three-dimensional signs such as shape and packaging of goods in some country. Non-traditional marks may be registered for distinguishing features such as holograms, motion, color and non-visible signs like sound, smell or taste. In addition to identifying the commercial source of goods or services, several other trademarks categories also exist. Collective marks are owned by an association whose members use them to indicate products with a certain level of quality and who agree to adhere to the specific requirements set by the associations. Such associations might represent, for example, accountants, engineers or architects. Certification marks are given for the compliance with the defined standard but are not confined to any membership. Now we will discuss how is a trademark registered. First, an application for the registration of trademark must be filed with the appropriate national or regional trademark office. The application must contain a clear reproduction of the sign fulfilled by the registration, including any colors, forms or three-dimensional features. It must also contain a list of the goods or services to which the sign would apply. The sign must fulfill certain conditions in order to be protected as a trademark or other type of mark. It must be distinctive so that the consumer can distinguish it from trademarks identifying other products as well as identify a particular product with it. It must neither mislead nor deceive customers nor violate public order or morality. Finally, the rights applied for cannot be the same as or similar to the rights already granted to another trademark owner. This may be determined through search and examination by the national offices or by the opposition of third parties who claim to have similar or identical rights. Now, we will discuss what are the copyright and related rights. Copyright laws grant authors, artists and other creators protection for their literary and artistic creations, generally referred to as a work so. A closely associated field is related rights or rights related to the copyrights that encompasses rights similar or identical to those of the copyrights, although sometimes more limited and of shorter duration. The beneficiary of related rights are performers such as actors and musicians in their performances, producers of the phonographs, for example, compact discs in their sound recording, and broadcasting organizations in their radio and television programs. Work covered by the copyrights include but are not limited to the novels, poems, plays, reference works, newspapers, advertisements, computer programs, databases, films, musical compositions, choreographies, painting, drawing, photographers, sculpture, architectures, map and technical drawings. Now, we will discuss what rights do copyright and related rights provide. The creators of the works protected by the copyright and their heirs and successors, generally referred to as a right holder, have certain basic rights under the copyright law. They hold the exclusive right to use or authorize others to use the work on agreed terms. The right holders of a work can authorize or prohibit its reproduction in all forms, including print form and sound recording. Its public performance and communication to the public, its broadcasting, its translation into the other language and its adaptation such as a form of novel to screenplay for a film. Similar rights of the among others, fixation and reproductions are granted under related rights. Many types of work protected under the laws of the copyright and related rights require mass distribution, communication and financial investment for their successful dissemination, for example, publication, sound recordings and films. Hence, creators often transfer these rights to the companies better able to develop and market the works in return for the compensation in the form of payments and or royalties. The economic rights relating to the copyrights are of limited duration as provided for in the relevant WIPO treatise, beginning with the creation and fixation of the work and lasting for not less than 50 years after the creator's death. National laws may establish longer terms of the protection. This term of protection enables both creators and their heirs and successors to benefit financially for a reasonable period of time. Related rights enjoy shorter terms, normally 50 years after the performance, recording and broadcast has taken place. Copyright and the protection of the performers also include moral rights, meaning the right to claim authorship of the work and the right to oppose change to the work that could harm the creator's reputation. Right provided for under the copyright and related right laws can be enforced by the right holders through a variety of methods and forums, including civil action, suits, administrative remedies and criminal prosecutions. Injunctions, order requiring destruction of infringing items, inspection orders among others are used to enforce these rights. Now, we will discuss what are the benefits of protecting copyright and related right. Yes, surely copyright and related right protection is an essential component in fostering human creativity and innovation, giving authors, artists and creators incentive in the form of recognition and fair economic reward increases their activity and output and can also enhances the results. By ensuring the existence and enforceability of rights, individuals and companies can more easily invest in the creation, development and global dissemination of their work. This in turn helps to increase access to and enhance the enjoyment of culture, knowledge, entertainment and the world over and also stimulates economic and social development. Then we will discuss what is an industrial design. In a legal sense, an industrial design constitutes the ornamental or aesthetic aspect of an article. An industrial design may consist of three-dimensional features such as the shape of an article or two-dimensional features such as the patterns, lines or colors, and these designs are able to make to look things attractive and beautiful. They also have the commercial value. Due to these reasons, the industrial design is protected. One has to register this design against limitation and unauthorized copying. The protection is provided for 5 years and it can be renewed for the 15 years. Then we will discuss the geographical design. Geographical indications and appellations of the origins are signs used on goods that have a specific geographical origin and possess qualities, a reputation or characteristic that are essentially attributed to the place of the origin. Most commonly, a geographical indication includes the name of the place of origin of the goods. Some of the products we use have association with the geographical indicators of the source, the thing like basmati rice of Dehradun, campanage of France, Darjeeling tea, etc. are the products which can be protected by laws and international agreement because they are geographical indicators of the source. Now, we will discuss how have the copyright and related rights kept up with advance in technology. The field of copyright and related rights have expanded enormously during the last several decades with the spectacular progress of technological development that has in turn yielded new ways of disseminating creations by such form of communication as satellite broadcasting, compact discs and DVDs. Widespread dissemination of works via the internet raises difficult questions concerning copyright and related right in this global medium. WIPO is fully involved in the ongoing international debate to shape new standards for the copyright protection in cyberspace. In that regard, the organization administers the WIPO Copyright Treaty and the WIPO Performance and the Phonographs Treaty, known as the Internet Treaties. These treaties clarify international norms aimed at preventing unauthorized access to and use of creative works on the internet. Then how are the copyright and related rights regulated? Copyright and related rights protection is obtained automatically without the need for the registration or other formalities. However, many countries provide for a national system of optional registration and deposit of works. This system facilitates, for example, question involving disputes over ownership or creation, financial transactions, sale, assignments and transfer of rights. Many authors and performers do not have the ability or means to pursue the legal and administrative enforcement of their copyright and related rights, especially given the increasingly global use of literary, music and performance right. As a result, the establishment and enhancement of collective management organization or societies is a growing and necessary trend in many countries. These societies can provide their members with the efficient administrative support and legal expertise in, for example, collecting, managing and disbursing royalties gained from the national and international use of a work or performance. Certain rights of the producers of sound recording and broadcasting organizations are sometimes managed collectively as well. In concluding remarks, we must say a common man comes across intellectual properties from dawn to dusk, the goods having a very wide spectrum and associated with food, shelter and clothes, the things of necessity, comfort and luxury, from waking up to the bed, using a comfortable sleep well mattress and pillows, having a cup of Taj Mahal tea, then wearing a Nike track suit and shoes for a morning walk. He deals with these properties, a modern bread or a Mother Dairy milk or a cup of Nescafe at the breakfast, going in a Zen car to the office using a compact computer and coming back in a car. In the evening, watching Sony television and fixing alarm in his or Swatch watch to wake up in the morning. He uses the products which are intellectual properties of someone. These properties have been covered under patents or a copyright or a trademark. Since a common man's life is very closely linked with these articles and products which are protected by the law under intellectual rights, the copying, imitation, adaptation and unauthorized reproduction of these things without the permission of the owner may amount to serious offense. Therefore, the knowledge about the intellectual property right is a must for a common man. Thank you viewers for watching this program.